Thank you, everybody, for joining us. This is called the Love Letter Workshop. I'm Jacques Bolivar, Certified Financial Planner, and we wanted to talk about not just the legal documents and the legal process behind estate planning, but give you some exposure to what it takes to communicate well and how to leave a legacy. So I wanted to borrow some words from Michael Josephson, uh, who wrote a poem, What Will Matter, and use that to kick us off today. What will matter? Ready or not, someday it will all come to an end. So what will matter? How will the value of your days be measured? What will matter is not what you bought, but what you built. Not what you got, but what you gave. What will matter is not your success, but your significance. What will matter is not what you learned, but what you taught. What will matter is every act of integrity, compassion, courage, or sacrifice that enriched, empowered, or encouraged others to emulate your example. Living a life that matters is not by accident. It's not a matter of circumstance, but of choice. So choose to live a life that matters. I think those words are very relevant and prescient when it comes to estate planning. And I wanted to share them with you. They're in chat if you'd like to see the full poem by Michael Josephson. And to the topic of estate planning, it's not always just about the papers and the documents. And so I wanted to share a little story about my grandmother, who didn't do very good at this communication. She had some of the loveliest recipes, those family legacy recipes that you would want to enjoy on Thanksgiving or the holidays, but she never shared them with anyone. They were her glory. They were what she was known for. But even for her children, when it came time to try to resurface the peach cobbler recipe, only people knew some of the ingredients, not all of them. And so I'm sharing this story because my wife and I, to honor her legacy, we did a recipe cookbook. And we asked you, the clients, and some of our friends and loved ones to share their family legacy recipes, just to remind everyone that it's important to share your legacy and share what's of most value to you, okay? And so that's how we went about doing it. And I'm going to share with you a little story and talk a little bit for a moment about what if you don't plan well. And so for us to think about that. So I recently had a difficult experience the last couple of days ago. I had the passing of a client. We'll call him today Bob, and his wife Sheila. And some time ago, he and his wife, while they're on the early years of their vacation in retirement, early years of their retirement, he wrote me this, and it says, "Aloha from Hawaii. Jacques, if you worked even harder for us, we could afford to buy a second home here and even let you know how, if you could use it and enjoy it yourself. Just saying, Bob and Sheila." So he loved Hawaii, and that was important to them. And they would often go there. And I wanted to bring up Bob and Sheila, not because he just passed a couple days ago, but because they did a really good job in planning. And when it came time to go into what I call the third phase of life, they were well prepared to enjoy it. But I wanted to now introduce our guest speaker, Brendan, and say, Brendan, first introduce yourself, please, but also answer the question, what if you did nothing? What would happen?
Well, hi, I'm Brendan Brewer. I'm an attorney. I'm in San Rafael, California. Known Jacques for many, many years, a large part of my practice is estate planning. If you do nothing, your estate's going to go to your heirs, but it won't go necessarily the way you want it to. If you do nothing, people will make decisions for you that you don't anticipate now making decisions for you. If you do nothing, it may be the courts that make the decisions. It may be your sister-in-law that makes the decisions when you didn't want her to do so. It's just going to depend. So the key for you really is just to make sure things get down in writing. And that's whatever your intentions are, getting them down, memorialized is critically important. It's not enough to tell somebody that this is what you want. You've got to get it down in writing.
Thanks for that, Brendan. So once again, I'm going to remind everybody, if you would ask your questions in chat, and Andy's going to make sure they come to me in an order that will make sense for the flow of the conversation. So feel free to use chat or use the gesture to raise your hand, if you would. So Brendan, it's important to put it down, but oftentimes clients will ask me, well, I know that most people, when they do estate planning, they have a will and a trust. Is they work in concert? Are they different? Some people need a trust and some people need a will. Explain that for us, please.
If you have nothing, that's called being intestate, and your assets go according to the laws of intestacy in California. It depends on the family, who's alive, who survives you. But the rules of intestacy are very specific about who gets what and what percentages. The next level is a standalone will where you can direct where you want things to go and how you want them to go, but it's administered in the California courts or in the state, wherever you happen to live when you die. That state court directs or mandates that the executor follow the directions set forth in your will. It's a public process, it's time consuming, and it's expensive. So many people opt for a living trust, and a living trust is what allows you to do the same thing as a will. You can direct where your assets are to go and who's to make decisions, but it's a private procedure. It is not administered by the courts. It's not, excuse me, it's not as expensive as a probate petition, and it's typically not as time consuming as a probate matter, but there are always nuances, but in general, so you have the three levels: being intestate, having a will, or having a revocable living trust. There's also pay and death designations that you can set up, which go above and beyond that, but those are unique to everyone's particular circumstances.
Okay, thanks for that. Again, I don't see any questions yet, so please raise your hand now, because we're quickly going to go from talking about wills and trusts to talking about the communication. So I see Erica has a question. Go ahead, Erica, and then everyone else, if you'd stay muted, please.
Yes. So I heard the term intestate. What does that mean?
That means you don't have a will. It means you have nothing in writing. So your assets are then distributed according to the California law and the rules of intestacy.
So Brendan, a lot of times we like to think about our estate planning in terms of our entertainers. So explain maybe that, Aretha Franklin, I've understood she had a holographic will, and then, Elvis Presley had a trust. Going back to your three levels, maybe use what you may or may not know about these entertainers to explain what a holographic or a trust planning situation versus.
Yeah, I can do that. I don't know the specifics of Aretha Franklin, but so you can have a will that's prepared by an attorney. It's all typed up. It's witnessed by 2 or 3 impartial witnesses, and it's then executed by you, and it's kept in your records. Anyone can write up their own will, and that's something that's done in their own handwriting. That's called a holographic will. Done in their own handwriting, it's signed and dated by the person who has written up the will, and it's legally effective. The problem with holographic wills is that people oftentimes forget, or they don't cover all contingencies. I have a holographic will I'm dealing with now where the decedent left percentages to her family members. Well, 15% of her gifts I can't distribute because those people predeceased her and she never changed it. And she didn't have an ultimate provision that said, if someone doesn't survive me, this is where my estate's to go. So now we have to go to court and we have to get the judge to decide where that 15% is going to go, because she, in drafting her holographic will, didn't leave complete or accurate instructions. So that's how a holographic will works. I can show briefly, if you'd like, Jacques, a PowerPoint on how living trusts work.
Can we get a show of hands? How many people are interested in hearing how living trusts work? Kind of more of a presentation from. I see one hand. I see two. Yeah, it seems like there's some interest. Go ahead, Brendan.
Let me answer Viveka's question, though. She says, is it necessary to have all three, or is the living trust sufficient? Those are three different scenarios. Either you have nothing, that's intestate, you have just a will, or you have a living trust and a will. So those are three different scenarios. So you wouldn't have all three, you'd be in one of those three categories. But let me explain what a living trust is. So living trust, basically, the main reason anyone would have a living trust is that you want to avoid probate. You want to make sure that it continues. You can leave monies in the trust, so it pays income over time to beneficiaries. It can leave money to specific individuals, but the main thing, you want to avoid probate and the expenses of probate. Also, if you're incapacitated, someone has a stroke, they get dementia, Alzheimer's, a trust continues to operate during your lifetime so that your successor trustee can come in during your lifetime and help manage your assets. A will doesn't do that. A will only comes into effect if you die. It's also private. As I mentioned, a probate proceeding is a court proceeding. Anybody can look at the files, anybody can see what's going on. Probates are handled privately and usually just with an attorney and the trustee of the trust. Living trusts also last a long time. I mean, if they're done right, you can have one done and you don't have to worry about it for 20 years. So what is a revocable living trust? Well, individuals can have a revocable living trust, or married couples. For an individual, a trust is like a bucket. You sign the trust documents, you put your assets inside the bucket. You put your real estate, you put your bank accounts, your investment accounts. You don't put anything that has a beneficiary like life insurance or 401ks, because those are paid directly at the death. But at the death of the person who has a revocable living trust, the assets are distributed and we don't have that expensive probate proceeding. Similarly, for couples, it's the same bucket. You put all your assets into that bucket. When the first spouse dies, we used to create what's called a subtrust called a bypass trust, and then another subtrust called a survivor's trust. There's lots of reasons why we don't, but we don't typically do that as much anymore. But at the end, everything goes to the kids at the death of the second spouse. What we're doing now is more of what's called a disclaimer trust. You still have that same bucket. When the first spouse dies, nothing changes. Everything stays in that bucket. When the second spouse dies, it goes to the children. And if they're minors, it can stay in trust. If they're adults, it can be divided up. If they have special needs, we can create a special needs trust. But ultimately, the estate goes to the beneficiaries. Everyone also needs a power of attorney for assets. They need an advanced healthcare directive, nomination of guardians, and if you don't have kids, sometimes you want pet care trusts or directives. That's just sort of a simple overview of the estate planning.
Thanks, Brendan. Now, our participants, many of them I know, aren't this quiet when I meet them in the meeting. So ask your questions, please. Now, I want to follow up. Can you go back and share your slide with the bypass trust, kind of, let's call it the old school? Do you mind sharing that again, Brendan?
No
So
problem.
can you speak to the 2017 Tax Act and the exemptions for gift tax? And a lot of times what in California, or if for some of our 401k participants in North Carolina and other places, people are concerned about death taxes, and most of the states for the participants today don't have state death taxes, but there's federal death taxes. Can you talk about that, how it changed and the sunsetting of the laws coming up?
Sure. So when the bypass trust, survivor's trust, it's called the AB trust setup happened, that was more in the late 80s and 90s, when the estate plan minimum was much lower, the state tax threshold, which meant that you could only pass 400,000, 500,000 to your heirs before what Chuck's referring to as a death tax. I call it an estate tax. And the estate tax is, for example, if you had $1 million and the estate tax threshold was $500,000, first $500,000 would go to your heirs free of taxation. The next $500,000 would then be subject to anywhere from 30 to 50% taxation. That's why with the living trust, we could double the exemption by creating a bypass trust and a survivor's trust. So that doubled it from $500,000 to $1 million. Well, right now, the estate tax exemption per individual is almost $14 million. And there are not a lot of people that have more than $14 million. So the need to double your exemption to 28 million is not as prevalent. And that's why we don't do the AB trust as much anymore. And what I mean by that 14 million is that you only have a death tax, federal death tax, and each state, the rules are different, but a federal death tax is only imposed after you get out, only if you have more than 14 million. In 2025, that's supposed to sunset, but it doesn't sunset that dramatically. It drops down to around 6 or 7 million. I don't know the exact number because it's going to depend on a number of factors. That means you have to have more than 6 million before you have to worry about estate taxes. And you still have the ability to double that if you need to 12 million. So again, if you're not worried by that threshold, then this bypass trust, survivor's trust example is no longer relevant for your particular estate plan.
So I'd like to summarize a couple of the key points that I heard. One was a living trust is a powerful tool, but you need to fund into it. So if I want to really highlight this point to everybody, because this is something that I see often, and that is people have done their will and trust and put their beneficiary designations, but then they forget the funding of the trust part. And so thinking of a trust as a legal safe that's paper in its construction, going back to Bob and Sheila, you know, if they had their home in Hawaii and they enjoyed that second home, but they did a great job of putting all their assets in California in the trust, titling it, but they never titled the Hawaii second home to a trust, then that would be a probatable asset. So you could have, you know, ineffectively executed your job because you didn't remember the step of funding everything. And so I know Brendan is very good about doing updates with clients. And so don't forget to do your updates and your life changes, and remember to fund your trust. It's that simple, but it's a very important thing to do. Would you add anything to that, Brendan?
No, that's just, if you don't retitle your assets in the name of the trust, then the trust doesn't really have a whole lot of value. You have to retitle. You have to fill that bucket with assets.
So
Janet had a question. Looks like
yeah,
Janet has a
Janet had the
question about.
Yeah, go ahead, Janet.
Yeah, so if obviously assets in California, a lot of value in assets is homes, and to retitle, doesn't that initiate a new assessment? Like if I bought a home 10 years ago and it's increased in value, but it's in my own name, to fund the trust with that asset, do I have to retitle it in the name of the trust? And by doing that, does that initiate a reassessment, which would affect my property taxes?
It would not trigger reassessment. That's actually statutorily exempt because it's not truly a change of ownership. It's just a change in the manner in which you hold title. So it would not cause reassessment.
Okay, excellent. Thank you.
All right, so I'm gonna encourage everybody, raise your hand or ask your questions in the chat. I'm gonna transition and talk a little bit about the how. And what I wanted to do is just take a few minutes to talk about some of the ways I see families, individuals taking care of the business of putting together the estate plan in terms of the documents and how they organize themselves. I'm going to begin with what I consider to be a fairly simple document this is something that comes from the caregiver California.org. And what I wanted to share here was that it's important to know the location of things. You know, if we go back to the story of Aretha, I guess the story was that she had a couple holographic wills, but I think one was even in the couch or something like that. So you got to let people know where you placed it. I mean, it's the simplest thing to say, but this is one simple tool here to document and share where your key items are. Now, what we're doing in our office, we're trying to take this online. So we use a planning platform where we do forward thinking about your nest egg and how well prepared you are for planning. But a feature in this is we have a vault. In that vault, we put some of these key documents, and in there might be your social media. It may be some bills that if one spouse or person in the family does some of the significant bills and the other really doesn't pay attention, you may want to keep a list of some of those key usernames and logins with a online system, but also have information here about where to go and handle that. So the organization, a central place, you know, so in the case of going back to the example of Bob and Sheila, you know, if Bob is the person that predominantly does the planning with us, and then now the baton is passed to Sheila because she's a widow, making sure her login is up to date and then giving her access, and we communicate the important information. And then this also has a private vault, if you will, that has things that you may not want to even share with our office. And so this is a great way to plan. Now I see some more questions coming in. First, there was Zena. I'm gonna let you go ahead and ask your question. And then I saw Lori after that. Zena, are you ready? All right. I don't hear Zena or see Zena, so I'm gonna say, Lori, go ahead and ask your question.
Thanks. I have a question. Oh, I'm sorry, Zena, did you want to go ahead?
No, yeah, can you repeat the question to me? I'm sorry.
Oh, I thought you had a question about trust, but you're really just providing an affirmation, I guess.
Yeah, yeah.
Okay. All right. Thank you, Zena. Go ahead, Lori.
Yeah, so my question is, if I have a trust with my husband that we created a few years back. When my parent passes away, he's planning on dividing his estate between myself and my brother, and it will be each in our names only. Do I need to create a separate trust for that that's in my name only, or can it be placed in the joint trust and earmarked in some way? Because my intention is for it to go to the kids when I pass.
So it depends on what your trust says. If your trust says that everything's community property, you may want to have property held separately in some sort of written agreement with your spouse about keeping that separate property. But if your spouse agrees it's not an issue, then you amend your trust to say that at your death, the property will be distributed to your children, regardless of the status of your husband, whether he's or your spouse, whether they are alive or not. So the answer that answer to your question is, you can achieve what you want to achieve, but it depends on what your estate plan documents say.
Lori, can you repeat that? I think you're on mute.
Oh, yeah. So I'm understanding it could be included in the trust that already exists with a note or an agreement saying that it's not part of the community property, if that's the intent.
Yes.
Okay. Thank you.
Yes.
Brendan, let's
Sure.
take it a step further. And I know this may not be Lori's question, but what if Lori was also interested in avoiding death taxes or minimizing the size of her estate, concerned maybe about a second marriage that might happen if she predeceases? You know, what are some of the things that happen in planning that you help with to then direct those assets to those daughters and or accomplish other goals, objectives?
Well, your property, the example of her property, I mean, she could gift that property to her kids at any point. You have a lifetime exemption of whatever right now it's almost 14 million. You can make gifts during your lifetime and there's no taxation on those gifts. There's reassessment for property tax purposes, but you could gift that property to your children during your lifetime. And then you just have to file what's called a gift tax return with the IRS, indicating that you made a gift to your children of the value of the property. So, or you can keep it, you can make the gift now, you can make the gift in 10 years. It's whatever the timing that you want.
And another thought to just kind of build on this idea of what I would consider in some ways property for the next generation, even though it's been inherited by one of the individuals planning. And that is, if it's ultimately going to the next generation and a goal happens to be education, 529 plans, education plans are effectively out of your state and grow tax deferred. Sometimes we have clients that if the asset is a IRA, they may convert it to a Roth because they know they're going to have more than 20 years of this money being put to work with no distributions. Then it's appropriate to give it its best tax status possible. So sometimes there's other planning opportunities around tax that come into that beyond just the estate question. Do we have more questions to see? Andy here shared, what do you recommend in the case of having beneficiaries outside the United States, in our case, Mexico? You're on mute, Brendan.
I mean, you can name a beneficiary in your estate plan documents anywhere in the world. How that affects them in that country, they'd have to get their own advice. But I have clients who name beneficiaries in Mexico, in Europe, in Asia all the time. They're named beneficiaries. There's oftentimes a language challenge at their death, so you have to make sure that they have access to someone who can give them advice. But as I said, my clients leave property and assets to foreign beneficiaries quite often. What you don't do, though, is you don't make a foreign citizen a successor trustee of your trust, because that creates all sorts of taxation issues that depend on the circumstances. But essentially, the U.S. government doesn't like a foreign trustee to be in charge of a trust, because in theory, they could take the trust to that country and the government would never be able to impose any taxes on it. So you want to be careful about naming foreign citizens as successor.
I'd like to just add, because I really wanted to emphasize today the communication. Very important when it comes to having someone that's not near your household or in your day-to-day life, that you have a central place that they become aware of. I have a client that has beneficiaries in Germany, and in her case, it was just simple enough sharing my contact information. I or other contacts are listed in the will and documentation as advisors to the trust. And there's some communication about the contact information with the professionals that you're dealing with, because if it's a language barrier or they're coming from somewhere else, they may need assistance. And sometimes in your planning or sometimes in the form of a letter of intent, you share some of the key contacts of the professionals. There's a lot of online binders and documents that allow you to centralize in the way that I'm using my example of the online version of organizing yourself. I also wanted to give Bruce a chance to ask his question, because I see a question formulated, but I didn't necessarily understand it. So Bruce, unmute yourself and go ahead and ask the question yourself. Bruce, please.
Hi, good. Thank you, Jacques. The question really is related to difficulty I'm having trying to decide the beneficiaries when I don't have children, but I do have three siblings that are my age, but don't really necessarily need the the outcome of my trust or whatever I provide. And thinking of my nieces, I have three nieces that probably would be better served to have that, whatever is available. And I'm not sure how to decide that. I'm very torn between the two different thoughts. Does that make sense?
Yes, yes. Brenda, would you like to take that first, and then I'll answer?
Yeah, I mean, it's a common question. What's important to you? Are you, I mean, your siblings have adequate assets if you want to pass on your estate to your nieces. I think that's it'd be a very nice thing for you to do. You may have some cause that's important to you, some charity that's important to you, um, some research department that's important to you. It's completely up to you. There's no wrong answer to that question because you can do what you want and the documents can achieve that. So I think that's a very personal question, and I think you can answer it ultimately. It's no one's going to judge you for the decision you make. It's what's right for you.
Right, right. I'd say, to Brendan's point, there's a personal decision. There's no right or wrong answer to that. If you're fortunate enough to know that the nest egg is big enough for your siblings, that's great, and then you can make a direct beneficiary designation. But there's also the per stirpes type of benefit. Beneficiary designation where you don't necessarily know the financial situation of the beneficiary, and you make sure it goes to that portion or branch of the family, the children of, if my brother or sister predeceased me, then it goes to the bloodline, the per stirpes, the branch. And then to the point of not having kids, some of you know that I volunteer for Santa Clara University as a regent, and part of that work is, to determine, is Santa Clara a good place if, Lisa and I leave something behind? Would they be a worthy organization to give it to, or for a particular purpose? So sometimes you have an organization, a sorority, a university, a church, and you find community other places besides children or siblings, and then you make gifts. But these are all things that are great for like one-on-one meetings to kind of contemplate your options. But I also would say a cautionary note is we have a lot of clients that deal with chronic care in the final 5 to 7 years of life. And so when we run the math for a retirement plan, a lot of times we think about it in good health, but we also need to contemplate the cost of care in our communities. If you're in California, memory care is easily over $8,000 a month. So a lot of times there's not a lot that is left, considering all the many things that can happen. So do we have other questions? Let's see, Andy.
One thing I will say, just to expand on what Chuck's saying, the biggest thing, or the best thing you can do if you're going to leave gifts to people, do it in percentages. Don't do dollar gifts. Everyone is very optimistic that they're going to have $1 million or $2 million when they die, and they want to leave it to all sorts of people. And very often, like Chuck says, that your estate's whittled down due to end of life expenses. And when you say 100,000 to this person and 200,000 to that person and $500,000 to that person, and you die with 75,000, it becomes a very uncomfortable process for the people trying to distribute your estate, because they can't do that. You can always divide a dollar into percentages, but and that's why I prefer percentages.
Very good. Brendan, when we think about some of the planning questions, can you spend a little bit maybe talking, because we haven't gone to healthcare directives. Do you have any kind of tips and things you suggest about creating healthcare directives and other planning that may not be about death, but in disability or in chronic care type of scenario?
I mean, the main thing, as I said, is put everything down in writing. From my experience, simpler is better. I appoint my spouse or I appoint my child to make decisions for me, and they know what to do. Some attorneys will prepare 7 or 8 or 10 page advanced healthcare directives where they cover every possible scenario. It's probably not terrible, but I like it when I say, I appointed this person and they know what to do. And then the document's no longer part of the decision-making process. It becomes the decision by the person that you've selected. You want to talk about donation of organs. You want to talk about who's going to make the decisions. You want to talk about maybe whether you want to be cremated or not. And you certainly want to provide a HIPAA release. But beyond that, writing down every single possibility in an advanced healthcare directive, I think kind of constrains the power holder because they don't have any autonomy.
Very good. That's very helpful. I wanted to share this here from something called 5 Wishes. And I'm just trying to share some tips and tricks to keep it simple or guide you. And what they do really well is kind of give you a simple option of some of the paths you can go. And if you're going to engage someone like Brendan, you might even want to kind of have done this exercise and created questions so that you're productive with your time thinking about healthcare scenarios. And the other point that I would also bring up here is have contingent powers of attorney, contingent or successor trustees. You know, I recently had a close friend have a stroke in his 50s, and the wife had to go to the emergency, and he's still in rehab. And it was such a traumatic situation to one, be nervous, and then you're there with your recovering spouse and they're referring to you as their sister, and it's stressful. And so you want to, in good health, contemplate contingencies, and we a lot of times put these things off because we think we're too young or it's too soon. But you need to be, you know, willing to have, you know, contingent backup people that, most importantly in my mind, follow directions. So, Vivica, I'm gonna ask allow you to ask your question. You raise your hand.
Yes, I just wanted to share, Jock, to your point. As the president of my sorority's charities, I was recently contacted by the executor of one of my sorority sisters' estate who had passed away. And she just contacted me, said that her aunt had left a sizable amount of money to the charities. And I had a couple of documents I had to send to her, you know, the incorporation of the charities. I had to send our tax filing. I had to send the 501c3 status, but she was not willing to tell me the amount that we would, you know, potentially benefit from. Is that typical of how they start the process of distributing the funds? Will I be contacted again for account numbers and stuff like that? I have her contact information, but it hasn't been long since she initially contacted me. And I just wanted to know kind of what would be the next step in this process.
So they have up to a year to start distributing assets. And part of the problem is if you tell a beneficiary they're going to get $200,000 and it turns out they only get $125,000, the beneficiary is upset and feels they've been misled. So you're entitled to a copy of the trust if that's what's if there is a trust. But as far as giving you dollar amounts, it's usually wiser that they wait till they have all the information and make sure that they haven't made a mistake about who's going to get the distribution before they start giving out dollar amounts, because once you do that, it's hard to backtrack from that information.
Vivica, I would also add to that, to Brendan's point about using percentages. When an estate in its distribution of assets uses percentages, sometimes you don't know how much money we're exactly talking about yet. Recently, we had clients who had all the grandchildren receiving educational money. And so there was one grandbaby that was born within the first year of passing. And so they wouldn't know that at the point of giving you a call. They were distribute those educational funds first to the grandchildren, and then charities and other beneficiaries are based on percentage. So they just may not know yet, you know. So that's what I would say, because sometimes planning is not as simple as a beneficiary designation. And that's one thing that's, I think, is a key differentiator about a living trust from a will, is it has legal life after your passing. So you can provide instructions to do any number of things. And so just be aware of that and explore that with your attorney or attorneys like Brendan.
Thank you.
Any other questions coming in? All right. New message. Let's see. All right. I don't have any other questions. So I'm going to consider that a breaking point. And I want to encourage everybody to, if you have maybe a new estate planning scenario, I'd ask that Brendan share his contact information. Brendan, you fine with that?
Yeah, I'll put it in the chat.
Okay. And clients that want to take this as an opportunity to maybe refresh what they've done and want to kind of do a review and help prioritize some things that we need to do in terms of your planning, be it as simple as you're a 401k participant and you need to update your beneficiary designation, or you've already done your will and trust, but it's been over a few years and maybe it's a little stale. You know, so keep all those things in mind. Also reach out to us by scheduling an appointment. We left the link into the chat that has my calendar. And as always, it's great to see everybody, and we'll let you know when it's been posted online. So thanks for your time and join us for the Love Letter Workshop.
Thank you, Jock and Brendan. That was very helpful.
Thank
welcome.
you. That was helpful. Even from Maryland, that was very helpful.
All right.
Thank you from Bruce. Thank you.
Thank you. Good to see all of you. Take care now.
Bye-bye.
Thank you. Bye-bye.